I wanted to reach. She got go early. Came up, so I'm like, you know what? I'm gonna go live and let Zeke say hi. I know nobody's here right now, but when you rewatch it, you'll see at the beginning. He's in the in-between stage of his grooming. Like, I like when he's real fluffy and furry, but he got shaved a couple weeks ago. My mom always wants to get him shaved so soon. I liked when he gets his long hair and he's nice and fluffy, but he's about in between stages. He's still cute. Ah, see a picture of me and Zeke down there? Obviously, it's not real. Anyway, I'm a little early. I just was wanting to show Zeke. He hasn't been on camera in a while. So cuddly. That's my baby. That's my boy. He's my love. He's a good boy. He's a very good boy. He's been a little not eating very good. We tried this new food and he was loving it for a while, and now the last couple of days he hasn't eaten very good. So mommy says no treats until you eat your food. He's spoiled. We used to cook him chicken and rice, and now she found this new food that he's been liking. It's like this, fresh food, but otherwise we have to cook him chicken. Sometimes we cook him beef, but mostly chicken and rice. Sometimes beef. Sometimes he gets, whatever, but mostly chicken and rice, huh, puppy? Okay. He's a little Lance. Okay, baby. Hold on, I'm gonna put you down. There's my baby. Okay. All right, let me let him out and then we'll start reading. I decided to do an early live because last night I almost wanted to go live again. Hold on, let me let him out real quick. 1 second. Okay, baby. I love you. You go ahead. Okay, don't slow down the stairs though, because you go too fast, you fall. Okay, slow. Bubba. Love you. Okay. All right. Decided to do an early live for y'all so we could get some reading done and it's not so late. It's not really a matter of being like late for me because I could stay up late a lot of the times. It's a matter of lately just sitting down too long and not getting able to move my legs has really been a concern. So, what's this? Hold on, let me. Oh, it's pushed down. Okay. Anyway, so let's go through these documents. And then like in the meantime, maybe I'll play that one interview with Olivia. And then she posted on which I didn't realize on TikTok, Casey. I think that's what you were saying. And she talks about them being sleeping. She talks about what I addressed yesterday, which is kind of crazy. Hey KB, hey Shar, hey Mazzy Star. Oh, Mazzy Star. I used to listen to Mazzy Star with my sister when we were younger in high school. Maybe even in grade school. Cool. All right, guys. Let me get all ready. I don't need my headphones yet because I might end up, like I said, playing a couple of videos, but until then, we will just read. So yeah, let's do this, guys. Let's just jump right into it. And good afternoon, everybody. Hi, Mrs. Wild. I'm gonna try to remember to stop and interact a little bit with people. I know last night I just got caught up for 2 hours reading through that list and I barely even talked to everybody. I won't do it too often because I know a lot of people just want to see the documents, but I'll try to at least engage a little bit. I felt so bad last night that I didn't at all. Okay. Wait. Oh, she did another interview? Let me make sure that you're gonna make sure that there's no audio where if I have a video, if something's playing in the background, it doesn't make a noise. Okay, everything is muted. Okay. Let's bring up what we were going over yesterday. Hi, Cassie. Hi, Lyra Massar. So we're talking about the Idaho 4 case. More documents, like 30 documents got released a few days ago, last week. I went over the exhibit list last night. If you haven't checked it out, it's pretty interesting. They basically describe all the photos. So a lot of those photos were redacted, like crime scene photos, where they describe what they are. So it gives you like a little insight of the injuries, which I felt it seems like we're misled now after you listen to Olivia. But I mean, Olivia's opinion, I mean, we're all just trying to figure it out. So her opinion is that she thinks that, well, I'm not going to speak for her. I'll end up playing what she thinks of it. But I still think there's a chance that Ethan did fight more than we thought. Even after listening to Olivia, I still think that he fought more. Like he didn't just lay there. Like I feel like there was a fight, but I could be wrong. I mean, the only thing that makes me feel that a little bit of doubt is because he was covered up, halfway covered up, and that's kind of weird because I don't think Bryan would have covered him up, and if he stood up, how did he get covered back up? That's the only little confusing thing about him. But if you haven't seen my video yesterday, it goes over like wounds that he had that are very interesting and way more extensive than what they said in the documents for some reason. I don't know why they didn't, when they're going over like the injuries, why they skipped over some of those. But I guess they figured that they'd see them in the pictures or whatever. Okay, so let me get my setting. All right. So let's start. I mean, there's no particular order. Let's see here. Actually, this one, I kind of wanted. This one I want to compare. So, I'm going to go back through the exhibit list and compare which ones are taken off, which ones they're redacted and stuff, because it's kind of interesting to see. So I'm going to wait to go over this one, this one. Okay, so let's do restitution. Okay. Now there's this document that goes over the restitution, and then there's like 4 or 5 other more that breaks it down even further. So depending on if you guys are bored with it, I mean, none of them are really that long. So I mean, but this one goes over. I forget how in depth, and if not, I'll go the other ones break it down individually. Okay. So I just thought that was kind of interesting what everybody got paid, like the families got paid for. Bryan's gonna have to pay him. All right, let me take a sip of this really quick before it gets cold. Wait, what are you saying, George? You said anytime Bryan, not a mark on him, total joke, and anytime Doc's hit Ashley and here, but Buddy, Bryan, and wait, what does that say? What are you saying about Ashley and here, but Buddy, Bryan, Etten? Explain that, George. I'm not sure what you're trying to say there. Oh, cool, Cassie. Okay. So we'll go over this one first is defendant's objection. So like, that's the objection. Well, I'll bring up the other, hold on. Do I have hold on. Let me just see something really quick. If I have the other ones pulled up. More Idaho. So restitution. I don't know if no, there's a bunch of them. Okay. So that's objection. Well, I'll read that first, and I'll pull up. There's 2. I forgot about that. When I was going over how many, I forgot about 2, 4, 6, 8, 10, 11 more. I don't know if I counted that. No, I did count that. There might have been more when I was counting them that I missed, actually. All right, hold on one second. Where did I restitution? Okay. I'll just go over this, and then there's like 10 other ones to go over on restitution. But Bryan Kohberger, by and through his attorneys of record, and hereby objects to the state request for additional restitution filed September 22nd. So he's trying to object to it. The grounds for objection are the plea agreement specified funeral expenses and funds reimbursed through Idaho Crime Victim Compensation Fund in an amount to be determined within 60 days. So from July 23rd, 2025, Mr. Kohberger stipulated to those amounts, resulting in court orders in the amount of $28,956.88 on August 29th. The additional funds sought do not qualify as an economic loss under Idaho because Steve and Christy Gonzalez and Karen Laramie received extensive funds through multiple GoFundMe campaigns that specifically asked for and covered the expenses sought. That's interesting that they're like, now remember, this is the defendant's rejection. So they're saying that it doesn't qualify as economic loss for some of them because they had those GoFundMes, which they didn't lose anything because they made up for that in the GoFundMes. Interesting, huh? Mr. Kohberger has no ability now or in the future to pay restitution because he is serving 4 consecutive life sentences plus 10 years. Procedural history. Oh my God, Zeke. It's because my grandma is down there by herself and she's making them think there's somebody there every second. She'll open the doors and look out the windows, and oh my Lord. This is probably why I'd never do day lives. A judgment was entered against Mr. Kohberger on July 23rd, 2025. Can you guys hear it? I feel better if it's not annoying you guys, because that's what's bothering me, because I'm trying to do a live, and if he's barking the whole freaking time. I always get reminded when I do day lives why I don't do them that often. I always forget, like, why don't I do them? And then I'm like, this is why. Ugh. It's either that or the lawn stuff, yard stuff. But that one's not as annoying, I don't think, for you guys. All right. So a judgment was entered against Mr. Kohberger July 23rd, 2025. The plea agreement stated that state may seek restitution orders regarding funeral expenses and crime victims compensation reimbursement in the amount to be determined. The judgment of conviction ordered $251,227 in criminal fines and fees, $20,000 as civil judgment for each of the families named in the indictment, and also directed the state to notice restitution for hearing if parties cannot stipulate to an amount within 60 days. With respect to the Crime Victims Compensation Program and funeral expenses, the party so stipulated on August 27th, 2025 to $28,956. And corresponding orders were entered on August 28th. On September 22nd, the state filed its state's request for restitution and motion to seal exhibit, seeking an additional $20,409. For Chris, I have a question though. Since he's not able to pay it, did the state pay that, or do they just have to wait and they never get their money? Or does the state pays it and then he has to pay back the state through if he works and stuff, right? I mean, they get that. Yeah, because on the other ones it says they got that they were paid that. So yeah, they get it. Okay. Seeking an additional 20,000. Okay, I already read it for Christy and Steve, and 6,920 for Karen Laramie. An itemized statement with receipts was attached under seal. No documentation showing reimbursement by the Crime Victims Compensation Fund was included. The receipts relate to travel and accommodation. So remember, this is the defendant's saying, what page am I on? 3. Defendant's objection to the state's request for additional restitution. Okay. So, plea agreement. The plea agreement is unambiguous about the restitution categories. Mr. Kohberger agreed to pay, and once receipts and verification were provided, he stipulated accordingly. This court must consider contractual terms that are expressly provided in the plea agreement, as well as those contractual terms that are implied. And they're citing a case, given the express language in plea agreement, the only additional receipts submitted that may fall within the contractual terms are those for the earns. The state has an obligation to stand by the terms of the plea agreement that Mr. Kohberger relied upon. Economic loss. A the code Idaho code defines economic loss as economic loss includes but not is limited to the value of property taken, destroyed, broken, or other harmed. Lost wages and direct out-of-pocket losses or expense, such as medical expense resulting from criminal conduct, but does not include less tangible damage, such as pain and suffering, wrong death, or emotional distress. Emphasis added. Several GoFundMe campaigns resulted in funds raised for the Gonzalez and Laramie families. Specifically, one GoFundMe campaign for Madison and Kaylee raised $73,493. These funds were promoted as going to both families. And you could click on it and let me see if it's still up. Yeah. Donation protected, 73,000, yeah. The goal is 40,000 and they raised 73,000. And it says, uh, God just received more angels than Maddie, May, and Kaylee. Fly high and be free, and you beautiful souls. Our hearts are broken with the tragedy and loss of the U of I students. These amazing girls were so kind, so sweet, so loving to all. Donations will go to Maddie and Kaylee's families. Jesse Frost is the organizer. Karen Laramie is the beneficiary. Yeah. Okay. So another GoFundMe campaign for Karen raised 48,815 to help Maddie's family attend the Idaho trial, and also clarified that the funds were in fact used to travel to Boise for hearings, including the sentencing. So here's theirs. 48,815. I write on behalf of the mother and stepfather of Maddie, one of the 4 college students murdered in Moscow, in what is now known as the University of Idaho killings, as most of the world has been made aware the trial for the deaths of Maddie, Kaylee, Xana, and Ethan will be in Boise from August through November. Maddie's mom and Karen and stepfather Scotty need financial support for travel, room, board, and lost wages to attend the trial in person. But see, since the trial didn't happen, oh, well, these documents were when they thought the trial was going to happen, right? Wait, when was this document? No, because they're talking about the plea agreement. So okay. So then, yeah, I mean, I could see how, of course, the defendant's going to object. I'm not saying they don't deserve that money, but of course they're going to object because they're going to be like, well, they didn't even, first of all, they didn't need the trial money because he took a plea deal. So they have all, I mean, I could see why they would argue it. Of course, I mean, they have nothing to lose, the defendant. So of course they're going to argue it. But let's see. Maddie's mom and Karen's stepfather, Scotty, need financial support for travel, room, board, and lost wages to attend the trial in person. The trial is expected to last 3 months. Their attendance is important to represent Maddie during the proceedings and potentially give victims impact statements. 3 months is a long time for Karen and Scotty to go without their normal wages. So let's help them with the ability to be there in person to represent Maddie and support the other victims and their families. Your funding will additionally help remedy the hardship caused by the criminal defendant moving the trial from North Idaho to Boise, 460 miles away from the home of Karen and Scotty. Funds will be used for a place to stay for those months, along with travel costs, loss of work, and bills still waiting back home. We ask for your kindness in this impossibly difficult time to help them fill the financial gaps. Any donations not used for these expenses will help raise funds for memorial scholarships. We love you all and thank you so much. George, who are you saying don't understand? Are you talking to me? Are you talking to somebody in the thing? Anyway, no, I'm not saying I'm just I'm trying to give objective uh statements of both sides of why they would be arguing it and why. I'm not saying that I agree with the defendant's argument, but why they would argue it and why, but they probably missed a lot of work just from trying to get over this. You know what I'm saying? Think about that. That'd be hard to freaking go to work after that. I mean, so that, I mean, I'm not saying they don't deserve it. That's not what I'm saying, but I don't even think you're talking to me. I'm just trying to give objective statements on both sides. All right, so now we have a third GoFundMe for Stephen Christie, raised $85,583 for the purpose of attending court hearings in Boise after venue was changed. Wow, what video is this going to bring up?
And the family of Kaylee Gonsalves, one of the victims in that Moscow case, is now fundraising to be able to attend the trial in its new location in Ada County. They said all 10 Gonsalves family members want to attend the trial. The money raised will help them with housing, disruption to work, and transportation to and from the courthouse. So far, they have raised more than $11,000. You can find that link to donate if you'd like on our website. Just go to creme.com.
Okay. And then what else did they link? Oh, the GoFundMe right here. Wow. As many of you read in the news, the Idaho 4 members case was been moved to Ada County, down by Boise. Kaylee's family has not missed one hearing or any court appointment since this has started, and they would like to continue to attend all of them, even though it is now in Boise. Now that the trial is looking like it will be in June of next year, the estimates are that it will last about 3 months. We are looking to find an Airbnb or a house for rent that will house all 10 Gonsalves family members, as well as their small pets, for at least those 3 months. Since there will be a huge disruption to their work and life, we also would love to raise enough money for meals, loss of work, transportation, etc. Thank you so much for considering. Many of you have been such a wonderful support to for their family. All funds will go directly to the Gonsalves family. Hey, Mama Mia, what up, girl? Thank you for being here. Hey, Cicely. Mama Mia, are you the only mod here? Thank you for being here. It probably helps at this time, huh? Is this time easier for you to be here or no? Okay, so given specific funds sought and obtained for expenses to travel to Boise, the request should be denied because neither family suffered an economic loss for which the state seeks reimbursement. Both families did indicate a desire to refund any donations after the case resolved after sentencing, but whether they were able to accomplish this or donors requested funds returned is not included in the state's motion. Inability to pay. Idaho Section 19 provides guidance in determining whether restitution would be appropriate and states that the court should consider the amount of economic loss sustained by the victim as a result of the offense, the financial resources, need and earning ability of the defendant, and other factors as the court deems appropriate. And it states State versus Fuller, economic losses are just above, and in light of the GoFundMe donations, the specific funds for which the Gonsalves and Karen Laramie seek reimbursement travel to Boise, there's no sustained economic loss. Additionally, Mr. Kohberger has no ability to earn money or pay money given his 4 consecutive life sentences, plus 10 years. Unlike other cases where the Idaho courts have ordered restitution for short and long prison sentences, Mr. Kohberger is different. He will never have the ability to pay restitution. And even though he stipulated to restitution amounts, there's no foreseeable ability for him to ever make payment. Under Idaho law, he will never be able to profit by way of book, movie, or entertainment of any kind. For all the reasons stated, Mr. Kohberger objects to the request for additional restitution. He waives his own attendance at the hearing on this matter and requests that he not be transported because his defense counsel will be present. Okay, so but there is more restitution documents. Let's see. I don't know if I'll read them all. There's like 10 of them. But let's see if we'll just kind of skim through them. Well, I think a lot of them are short. Yeah, they are. They just give the amounts. So yeah, actually we could go through them. Okay. So Latah, come down by through Latah County prosecuted attorney and defendant by and through his attorney of record hereby stipulate to the entry of restitution orders herein as follows. Crime Victims Compensation Program, $14,393. Jim and Stacy Chapin, $5,720. Jeffrey Kirk Cornodal, $8,884 or $43. Total $28,956.88. So I have a question though. Why? I wonder why they got so much less than the Gonzalez. It looks like, but hold on. Let me just go through them all because I didn't thoroughly go through them, so maybe not. Defendant further agrees to pay restitution with interest at the judgment rate from the death sentencing through Ada County Clerk's Office. Now we have order of restitution. Okay. So the other one was trying to object it, but here's the order. I guess this is still specific. On August 26th, the party stipulated the defendant owes restitution to the victim, Jeffrey Kirk Cornodal of Avondale, and judgment is hereby entered pursuant to Idaho Code, blah, 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 against defendant and in favor of Jeffrey Kirk Cornodal in the amount of $8,843 payable through the Ada County Clerk's Office with interest thereon at the judgment rate of 9.125 per annum for the date hereof until paid in full for such further costs and disbursements that may hereafter accrue in this action. And then we have August 26th, the party stipulated that defendant owes restitution to Jim and Stacy Chapin of LaConner, Washington, and judgment is hereby entered. Against defendant in favor of Jim and Stacy in the amount of $5,720 payable through Ada County with the interest therein of the judgment 9.125. Shouldn't it all be the same, each family? Why would it vary? That's what I don't get. They shouldn't, I don't think they could be judged who went through more of what. I mean, it should all be the same. Unless if they're just going by how much they make and then wages lost, but I don't know. I guess pain and suffering would all be the same, but then the wage loss would be different depending on how much they make, maybe. I don't know. I'm not going to pretend that I know. I mean, I guess I could Google it, but I'm not going to get too in depth in this because I've got other stuff to go over, but we'll just go over the documents. On August 26th, the party stipulated that the defendant owes restitution to the crime victims' compensation. So they $14,393 is payable to Ada County clerks with interest therein, judgment, blah, blah, blah. So the crime victims compensation. I'll exit out of that. Okay. So to Jeffrey Cornodal, he gets $2,500. I'm gonna exit out of some of this so it doesn't get too full because sometimes Adobe just sucks lately. It freezes up. Lately, I should say the last year it's been sucking. Okay. Now we got Karen Laramie gets $2,500. Okay. So Steve and Christy Gonzalez in the amount of 5,000. Okay, so they're getting 2,500 a piece. So 5,000 because it's two of them. Okay. So that's the same, really. Yeah, I guess it is all the same. Jim and Stacy Chapin is 5,000, so it'd be 2,500 a piece. Kara Cornodal, 2,500. That's that was Xana's mom, and then Jeffrey, Xana's dad, and okay. Ben Mogan, 2,500. That's Maddie's bio dad. I think my mom's home. I think that's why he's barking. So hopefully he'll stop. Yeah, good. So he should stop now after she gets in. State request for restitution motion. So that one we first read was they're trying to go against it, but this is the state's request for restitution. So I'm just going to kind of skim because it's going to say the same thing. They order a restitution here against defendant in favor of Stephen Christie in the amount of $20,409. In favor of Karen as 6,920. That's why I'm confused because this is saying a lot more, but then we seen, why do these say only 2,500? I guess the state was asking for more, but they only got that much after they've argued. Is that what you guys are getting from that too? So this is what the state's asking for, right? So 20,409 in favor of Karen Laramie, or that's for Stephen Christie. And then 6,920 for Karen. In support of this request, the state refers to the court and counsel to the documentation appended here too. Defense counsel has indicated they will meet with defendants this week to discuss possible stipulation. The state will advise the court if a restitution hearing is needed. So is that what happened? You think they came and they just decided, the judge decided on something a lot lower? I guess. I don't know. Because it looks like they didn't get, but I wonder, what I'm confused about is why was the state asking for 20,000 for Gonzalez and then, almost 7,000 for Karen, but then in the state's request, they didn't have anything for the Coronado family or, Chapin family. I don't know. Unless that was just a separate case or something. I'm confused. Okay, so that's the restitution stuff. So wait, question. Anybody, oh shoot. Anybody surprised, in the amounts? So I'm just checking out my different things here. Anybody whoa, that's big. Why is that over? Anybody surprised though, like thinking it would have been less, more? Oh, sorry, I'm on mute. Shoot, how long was I on mute? I was looking up if he's driving me nuts. I'm gonna have to go down because sometimes he just wants something, and I'm the only one that usually figures out what it is. Hold on a second. Mom, can you see what he wants? Are you sure? Because I'm on a live and he's being really fun. Look on that table. Make sure there's nothing. He's looking right here. Put the food out and stuff. Come on, oh my God, he's been so annoying lately. Yeah, but him and his food, he's been so annoying because he won't eat his food. So he wants treats, so he barks until, oh my Lord. Okay, anyway. So you could see it says the criminal is responsible for paying restitution to victims with payments made directly to the victim or through the court. A judge orders the offender to pay for specific losses, and the payments can be made through a percentage of prison wages, wage garnishment, or by using other assets like frozen bank accounts or a lien on property. If the criminal fails to pay, their assets can be frozen or seized, and other legal actions can be taken to enforce the order. So yeah, they're going to be getting them the rest of their lives in little increments. And the thing is what was that case? Remember that one case where they didn't want restitution because they didn't want that link to the person? Because it's like this, that means forever they were going to have this link and getting paid to the person that murdered their family member, and they just didn't want it. So what was case was that? Remember when we were I covered it, whatever it was, but they like, no, we don't want restitution. We want to cut ties to this person. But yeah, they'll never get it. Okay, I see. So yeah, they probably just decided on a smaller amount because what's the point? You're just going to be connected to this person till the rest of your life, basically, and you probably still won't get it full for the rest of his life. You won't get it paid. So yeah, I get it. Okay, so good thing they did do freaking GoFundMe's. You know what I'm saying? Because I mean, they wouldn't have got that money from him, especially if I know there didn't end up being a trial, but okay. So what is this here? We'll just kind of go nothing's in order. There's no particular order. I'll go through these. I'll just kind of click on it and see. So this is state's first supplement request for discovery disclosure. Records from the forensic psychiatric evaluation of Dr. Eileen Ryan. Okay. It says all written reports, handwritten or typed notes, scoring sheets, behavioral observations, or psychological data collected during an in-person forensic psychiatric evaluation of Bryan Kohberger on October 20th to October 22nd in 2024. So last October, and January 2nd to the 4th, 2025. So just last January at the Ada County Jail. All documentation and materials, audio, video, note summaries from the group family. Evaluation conducted on November 29th with Michael Kohberger, father, Marianne Kohberger, mother, Amanda Kohberger, sister. So the state's asking for discovery disclosure. Okay. And asking for this stuff. Okay. So the evaluations of his family, in-person individual evaluations of Marianne, Amanda, and Melissa. So Melissa's his other sister. So this is a group family evaluation. So that's kind of weird. The group family, they did it with Michael, the father, mother, and one sister. But in-person individual evaluations, they did it with the mother and the two sisters individually. And then you have phone and video interviews from the mother, Allison Ackerman, Ellen Trexler, and Dr. Ellen Novick Cohen. I forget who all those are. I know those names sound familiar, like I should remember. One of them's probably the professor, right? What was her name? Um, that's the mother, but which one? Who's Allison Ackerman? Anybody know? Um,
I don't know, Hater. I think so. I think they get a certain percentage of it. I do. Um, that new Elantra he wanted out went out the window with those 5 building plays. Hey, Hater. Um, I want to look up. All right, let me look. Mm, 1 second. So I was just looking at chat. Man, I wish I would remember. Because there's like Allison Ackerman, there's a few different ones. There's a neuroscience, psychologist, mental health therapist. I don't know. I have to go back through the documents. There's just been so much. Um, Ellen Novick. I forget which one was the professor. What was her name? Why can't I think of her name right now? Ellen Novick is there's a Ellen Novick Cohen, PhD psychology. Okay, but anyway, phone and video interviews, all investigative, where are we at? All investigative materials relied upon, including audio, video recordings, Bryan Kohberger's educational and medical mental health records, any other third-party documents relied upon during the evaluation. Hold on 1 second. Okay. So sorry, just got a little sidetracked here. Oh, that's right. What was her name, Bryan? One of those was her. I remember that. Here's a trial pen. Yes, I remember that. Wow. Which one was her name, Bryan? Mama Mia, I sent you a messenger message. Will you look at it? Anyway, okay. Did I send it to the right person? Yeah. Yeah, on Facebook. Oh, it just now got delivered. Wow. That took a minute to go through. That's why. That was weird. As soon as I seen your little picture, the delivered went up. So it must not have. That's weird. That was a really long delay. Okay. Anyway, let me see what you guys are saying because I did ask a couple questions and I'm just curious because I don't know which names. I forget. Rebecca Schofield. Oh, okay. Wait, so Rebecca Schofield was the one that has the trial pending? Is that what you're saying? For defamation? Okay, so neuropsychological evaluation materials, Rachel Orr, PsyD, all raw data protocols and response forms, including score sheets, handwritten or computer generated, examiner notes, and behavior observations for following assessments. So it's similarities, vocabulary, information, comprehension, block design, visual puzzles, matrix reasoning, figure weights, digit sequencing, running digits, digit span, symbol span, additional tests, controlled oral word association, stoop color word test, Wisconsin card sorting test, Tower of London. So a bunch of tests, Trail X, Iowa gambling, blah, 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 all these tests. We have Beck anxiety, Beck depression, behavior rating, inventory, Connor's adult ADHD, social responsiveness, adaptive behavior, autism diagnostic interview, examiner's handwritten type notes, all recordings of interviews in person, phone, Zoom, FaceTime. So they're basically the state's requesting all this information from the defense, right? Um, the discovery, because this is all the research they did and they requested it for discovery for the trial. I know it didn't happen, but they didn't know it wasn't going to happen. Documentation of dates, all materials used to form the basis of clinical opinions. Okay, so that's that. Um, go over this. I want to be reminded what I have. Let's go over this next since we went over that other one. I'm trying to think. Maybe it is better if I keep this up here. But what happens if I see. Maybe not, because if I do this, I could bring that over and yeah, I might do it like that. Okay. I just got to remember my head's blocking. Hi, Christina. Thanks for coming. Hey, Texas Ranger. Nice to see you. Why is that going over my head? That should raise it up. I swear I had that where it should raise that up. Hold on. Show display name, show headlines. Huh. Okay. Sorry, I'm just looking at why that's doing that. Huh. I don't know. Hold on, just give me 1 second, guys. I'm sorry. I'm trying to find the I don't know where it's at. Where it shows where display messages on stage. Huh. Yeah, it does have him shifted. Anyway, okay. Does this? Yeah, I'm gonna put those up there. All right, I'm ready now. It doesn't seem to go over the. Let me take this down. All right. Defendant's second response to state's first supplemental request. So records from the forensic psychiatric evaluation by Dr. Eileen Ryan. All written reports, handwritten or typed notes, scoring sheets, behavioral observations, psychological data, in-person forensic psychiatric evaluation of Bryan on October 20th. So Mr. Kohberger produces notes written by Dr. Eileen Ryan throughout her evaluation process of Bryan Kohberger. So they want to see the notes, all documentation of materials, audio, video notes from the group family. There were no evaluations of family members. However, Mr. Kohberger produces notes from the meetings. So I'm sure they mean the father, right? Because it says Mr. Kohberger. Because it's not, Brian's not even in here, right? And then we have so it's going over what little specific things here. So in-person individual evaluations. So for the in-person, it says there were no individual evaluations. However, Mr. Kohberger produces notes from the meetings. And then the phone interviews, it says Mr. Kohberger supplies interview notes from the meetings. No, he's not even in this. So I'm confused. What are they talking about, Mr. Kohberger? He wasn't. I don't know. It doesn't even make sense. Anyway. All investigative materials relied upon, including, and it says materials relied upon were provided in discovery to the state. Okay. So I guess I should have just went over this instead of the other one, because this is the same thing as we just went over, but it has a little thing on the bottom. It says, per stipulation, Dr. Orr will transfer testing data directly to the state's expert upon receipt of identification and transfer protocol. And then it says Dr. Orr will transfer testing data directly to the state. Same thing. Interview notes are disclosed herein. No testing data otherwise exists, other than as disclosed in requests 1 and 2 above. And then it says all materials used to form the basis of clinical opinions and conclusions. All materials relied upon for the basis of opinion and conclusion is disclosed through disclosure of testing data and interview notes. All other materials were disclosed in defendant's discovery response on January 9th, 2025, or discovery materials supplied by the state and noted in Dr. Orr's written reports. Any interpretive guides, scoring software output are subject to copyright and not reproducible. They are available for purchase directly from the test publishers for qualified professionals. The request for standardized references is a very general request, as Dr. Orr regularly consults a wide range of resources, including medical journals and reference books and other resources to maintain competence as a board-certified neuropsychologist. She did include a sample of references within her report. Okay, so that was kind of just repetitive. Okay, so let me see what I want to do. That's the witness list, which we got. I'm going to go over some of the shorter ones first. Okay. So this is parties' joint proposed jury instruction regarding tips leading to investigation of the defendant. So it says, the state of Idaho defendant Bryan Kohberger to submit the proposed jury instruction as provided below. Introduction. In its April 8th, 2025 order memorializing oral rulings in motion in limine, the court advised the parties to meet and confer regarding a jury instruction to explain the tip that caused law enforcement to investigate defendant. The parties have agreed on the proposed jury instruction below, which relates to the testimony of Moscow Police Department Corporal Brent Payne. The state intends to ask foundational questions of Corporal Payne to elicit the testimony addressed in the proposed instructions. Specifically, the state intends to ask whether law enforcement received tips that it investigated between November 13th, 2022 to December 19th, 2022. If any of those tips had been substantiated, and if law enforcement received a tip on December 19th, 2022 that caused them to investigate the defendant. Defendant does not stipulate to parts 1 and 2 of the anticipated testimony and reserves the right to cross-examine Corporal Payne about that testimony, but will not address investigative genetic genealogy, IgG. Proposed jury instruction. Parties joint proposed instruction number 1. You heard Corporal Payne testify that the investigation team received a tip on December 19th, 2022 that caused them to investigate the defendant, Bryan C. Kohberger. This testimony was admitted for the limited purpose of explaining what caused law enforcement to investigate the defendant. You are not to consider this testimony for any purpose other than the limited purpose of when and why law enforcement first investigated the defendant. You are not to speculate as to the source or substance of the tip. The parties respectfully ask the court to adopt the proposed jury instruction. Okay. All right. Oh, I'm going to compare that with the list. So I have to bring that back up. We'll do that last. So here is, let me get out of this. Let me take another sip of this. Hey, Gina. Hater, but how would you face those families saying their impact statements with a stony face? Hitler was not going to allow Ian to do anything. He was getting a fair trial. He wasn't getting a fair trial, Christina said. Okay. What else you say? Who got extorted or who was doing the extorting? It's in the latest doc drop. Does anyone know? No. Thompson said it wasn't true. When did he say that, Christina? Okay, so let's continue here. This is notice of filing defendant's objections to the juror questionnaire under seal. So the defendants, Bryan Kohberger's defense, their objections to the juror questionnaire under seal. Okay, so let's see. Bryan Kohberger, by and through his attorneys of record, and hereby submits to the court's defendant's objections to the jury questionnaire. Part 1, general background. Questions 3 and 8 are the same questions. So they're saying 3 and 8 are the same question, probably saying why we don't need the same question. Question 21 combines defense requested questions 19 and 20. Defense objects to the topics being combined. Okay. So it looks like he wants one of these dropped. He wants 21 dropped out because it combines. Question 23, oh my God, why can't I say that today? Queries about reading habits. The defense requests a new query about media habits to be added next in sequence. The defense requests the question cover traditional mainstream media sources, as well as social media sources, including following YouTube, TikTok, and Facebook groups. Part 2, employment history. Question 31, queries about employment. The defense requests part of the query include information about the prospective jury's role as a supervisor. Juror's role as a supervisor, sorry. Wait, the defense requests part of the query include information about the prospective juror's role as a supervisor. Question 32 queries about education or training in a variety of areas. The defense requests vehicle identification be added to the list. Part 2, education. Question 36. The defense requests the query including the prospective juror's major and minor fields of study. 4. General attitudes and knowledge of the law. Question 38. The defense objects to this wording and requests the wording in defense suggested questionnaire number 36 be substituted. That language, wait, so the word in defense suggested questionnaire number 36. Okay. Presumption of innocence. One of the fundamental principles of our legal system is that when a person is charged with a crime, he must be presumed to be innocent. The presumption of innocence is only overcome if the prosecution presented enough evidence to convince you beyond a reasonable doubt that he is guilty. If you are selected as a juror in this case, will you have any difficulty accepting or applying the rule of law that Bryan Kohberger must be presumed to be innocent? Yes or no? The defense has noted that the suggested query regarding burden of proof, the defense requests the following language be added into the final jury questionnaire. Okay, so let's see how they change it, or they want to change. The state prosecution has the burden of proving that Bryan Kohberger is guilty beyond reasonable doubt. Let me see. The burden never shifts to the defense. The defendant never has to prove that he is innocent. No defendant is ever required to testify. A defendant is not required to present any evidence. It's a little bit redundant, don't you think, though? I feel like if the prosecution does not prove every element of an offense beyond a reasonable doubt, the jury must find the defendant not guilty of that offense. So if the prosecution does not prove every element of an offense beyond a reasonable doubt, the jury must find the defendant not guilty of that offense. Do you understand this legal principle? Yes or no? Will you follow this legal principle? Yes or no? Do you foresee any difficulty in applying this legal principle? Yes or no? So they want that to be added, right? Yeah, be added to the language in the final juror question. So they say do this and then add this on top of it. I mean, I see why they would want it to be added, but I would see why the state wouldn't want that to be added. Anyway, the defense requests the following version of the constitutional right to remain silent be given. Under our Constitution, a defendant in a criminal case has the right to remain silent. A defendant is not, or a defendant is 13, not required to testify or to present any evidence at all. Do you feel that a defendant should be required to testify? Yes or no? Remember, this is the jury question. In many cases, a defendant with the advice of their attorney may choose to not testify. There are a variety of reasons this decision may be made. If this happens, do you believe it means that the defendant is probably guilty or has something to hide? Yes or no? If Mr. Kohberger does not testify, will you agree not to speculate as to the reason? Yes or no? If Mr. Kohberger does not testify, will you be able to presume his is innocent? His is innocent, yes or no? Wait, is this what they... Well, I want to see. So yeah, they wanted to add this, right? It looks like, right? Okay. To the jury questions. The whole thing. I just wanted to look like, or is it just one part they're adding? But it sounds like this whole thing they want to add, right? I mean, as far as that, none of it's on there, and they're asking to add that as a juror question. This whole thing, right? Okay. So if Mr. Kohberger does not testify, will you be able to presume his innocent? His is innocent, yes or no? If the defendant exercises his constitutional right to remain silent and does not testify, The jury will be instructed that they may not use his silence as evidence of guilt, and the jury may not even discuss the fact that the defendant did not testify. Can you follow this instruction and not consider the defendant silent as an indication of guilt? Yes or no? Question 40 and 49 will not, while not worded identically, cover the same information. Wait, questions 40, while not worded identically, cover the same information. Okay. So what do they want and want it not to be there? One of them to go. Well, they're kind of redundant in some of the stuff they want to add, though. So, of course, I mean, every side's gonna try as much as they can. Okay, so wait, what are you saying? Okay, so question 50 and subparts. The defense objects. The question and subparts are work to expose views of opposition to the death penalty. This is objectionable under Morgan versus Illinois. The defense requests that prospective jurors receive the question proposed in the defense requested questionnaire as follows. In this case, the state has filed a notice of intention to seek the death penalty. This means that if and only if Mr. Kohberger is found guilty of first-degree premeditated murder, there will be a separate trial known as a sentencing proceeding. During this sentencing proceeding, other evidence may be presented to the jury. You are not to draw any conclusions about why you are being asked questions about the death penalty before this trial has commenced. Do not think that anyone has determined that a sentencing proceeding will be required or that Mr. Kohberger will be found guilty of any offense. This is very important. If the defendant is convicted of first-degree murder, the same jury that determined guilt may be asked to determine the appropriate sentence in a separate proceeding. In the sentencing phase of the case, the prosecution is required to establish the existence of an aggravating circumstances. Which the prosecution asserts support the death penalty. On the other hand, the defense will present mitigating circumstances to the jury, which the defense asserts support a penalty of life imprisonment. Aggravating circumstances are factors set out by statute and alleged by the state in support of the death sentence. Mitigating circumstances are anything about the defendant or the facts of the case that, in fairness or mercy, indicate that a sentence other than death is appropriate. If you find the defendant guilty, the alternative to the death penalty is a sentence of life imprisonment. Are you opposed to discussing your viewpoint about the death penalty with the parties during voir dire? Yes or no? Do you feel the death penalty is used too often, too seldom? Don't know. Please explain. Question 51. Defense requests the following question to be asked following 51 or 51 be eliminated. Wait. Defense requests the following questions to be asked following 51 or 51 be eliminated. Have you participated in Idaho legislative process regarding any aspect of the death penalty, including how Idaho carries out the death penalty? Yes or no? Question 53. Defense objects. Discussion of a prospective juror's feelings about the death penalty is more appropriate in person so the court and the parties can assess the prospective juror's responses. Wait, it says question 53, defense objects. Okay. So they're saying discussion of prospective jurors' feelings about the death penalty is more appropriate in person. So the court parties can assess the prospective jurors' responses. Okay, sounds like they want to object that because then they want to actually talk about to them as when they pull them up in person, right? Part 6, knowledge of the case. Question 56. Defense requests the prospective jurors be asked if they have watched Dateline episodes. Defendant requests the following question be added. If you did follow this case, has that caused you to already form an opinion regarding the guilt or 32 innocents Bryan Kohberger in this case? I guess it's to form an opinion regarding the guilt or innocence regarding Kohberger in this case. Yes or no? Question 61 and question 62. Defendant objects. The coverage of this case has been pervasive. It is in the media every day. There has been a lot of misinformation through the pendency, and any prospective juror that has read, heard, or watched the coverage cannot set aside what they have read, seen, or heard. Bias runs deep and strong depending on many potential connections to the case or to stories read, seen, or heard. The change of venue was granted for this reason. The defense noted that the requested questions related to Mr. Kohberger's diagnosis, and we request that query be added back in. The query is, oh my God, why can't I say that sometimes? Wait, the defense noted that the requested questions related to Mr. Kohberger's diagnosis, and we request the query be added back in. The query is, the evidence in this case may include testimony about autism spectrum. Sorry. So they're saying the evidence in this case may include testimony about autism spectrum disorder, obsessive compulsive disorder, attention deficit hyperactivity disorder, and eating disorders. Do you have a strong opinion about hearing that kind of evidence? Yes or no? If yes, what is that opinion? Which disorder? Are you familiar with autism? Yes or no? Have you or a family member or close friend been diagnosed with any of the disorders listed above? Yes or no? Okay. I'm going to save this because if we go over the jury questions and we have time at the end and we want to compare which ones they wanted out and we want to see which ones and what they were, we could do that. I'm not sure. We'll see how that goes here. How much time we got. Okay. This is a short one, so let's go over this one, 2 pages. So this is parties proposed stipulated jury instruction. Come now, the state of Idaho, Bryan Thru, Latah County prosecuting attorney, and the above named defendant, Bryan Thru, the undersigned attorney, hereby stipulate to the attached proposed jury instruction, consistent with the court's directive contained in its April 17th, 2025 order on defendant's motion in limine, Rylan Nolan and touch and contact DNA. Wait, parties proposed stipulate jury instruction. Huh. Okay. During testimony, you may have heard certain witnesses refer to touch DNA or contact DNA or trace DNA. To the extent that those terms may have been mentioned by a witness, you are to disregard that particular term and not give it significance as you consider the evidence or testimony related to the use of the term. So wait, it's saying to the extent of that those terms may have been mentioned by a witness, you are to disregard that term and not give it significance as you consider the evidence or testimony related to the use of the term. Okay. All right. I guess it was that way. So state's proposed supplemental jury instruction. So becomes now blah blah blah. Pursuant to the court's directive contained in the first full paragraph of page 13 of the April 17th order on defendant's motion in limine, Rylan Nolan and touch and contact DNA. The state respectfully submits the attached draft jury instruction to be used in the event the terms touch DNA, contact DNA, and trace DNA are inadvertently used during trial. The state acknowledges that the court's request was to submit a mutually agreeable instruction. However, the parties have been unable to reach an agreement, so the state is submitting its draft for the court's consideration. State's requested instruction. The court has asked the witness refrain from using the term touch DNA, contact DNA, and trace DNA. To the extent that those terms may have been mentioned by a witness, you are to disregard that particular term and not give it significance as you consider the evidence or testimony related to the use of that term. Oh, it's the same exact thing, sorry. Because one of them is the state's proposed supplementary instruction. Yeah, sorry. I should have only kept one of those to read. Okay. Let me see what else we got. So this is notice of amended exhibit list and motion to seal. Oh, that's the one I'm going to go through when I get the list. Okay, hold on. When I bring up the list again. So this one's 13. I kept that because I don't know if we want to go over that once we get. Okay, so let's read this here. So wait, this and this will be ones. All right. I'll just read this real quick, but then I want to actually kind of link it to, because they're asking to like redact some of that evidence list or switch them out, like the photographs and stuff. Well, I'll wait till actually I bring up the list. Yeah, because why would I go over it twice? Okay, so let's do, what is this? This is Exhibit F to defendant's 6th supplemental response to discovery. The following items have previously been disclosed as exhibits by the defense and are now being disclosed in discovery in abundance of caution. Okay, let's see. Let me take a sip of this. All right, so we have photo TSM trunk contents, goggles, weather on 12/14/22, weather 12/15/22, MPD press release. So a bunch of press releases from the 13th of November, 15th, 16th, 18th, 19th, 20th, 21st, 22nd. All these presses all month of November, all month of months of December basically. Okay. I don't think there's anything. Yeah, just press releases. Okay. This is the following items have previously been disclosed as exhibits by the defense. The defense intends to use these demonstrative aids in trial. Although typically not discoverable, the defense is disclosing these items in discovery as a courtesy and in an abundance of caution. Connections of a demonstrative exhibit, Ballard PowerPoint DNA transfer in the University of Idaho case, PowerPoint understanding DNA transfer, Shuttler PowerPoint, Bright Burnham PowerPoint taking inked fingerprints, ACE methodology. So you can see this is the defense's exhibit. So what they want to present, right, for their defense. So they're going to do like a DNA transfer to show a PowerPoint on that, understand a DNA transfer. which you can see where they're probably going to go with that. Inked fingerprints, ACE methodology, ACE, whatever ACE, where is that? ACE, I have to look that up. What does that stand for? I know once I see it, I'll be like, oh yeah. Oh, it depends on the context. Okay. I don't know. We'll do that later. I don't need to do that right now. Okay, so we have where are we at? Bright Burnham comparison to exclude PowerPoint Barbara Wolf, MD. PowerPoint Syre. And then we have saying the same thing about the exhibits. And there's all of these items are summaries of discovery previously disclosed by state. The defense is disclosing these items in discovery as the courtesy. Disclosed as exhibits by the defense. NoT on video, overall house, NoT on video, third floor again, third floor slow, down 1, and Dylan 2. And then we have Dylan 3, Dylan 4, Xana exit from kitchen. So it looks like a video they took of the house. Which I remember hearing about that because remember they wanted to make the model and the house was going to be torn down and then they didn't give the defense a chance to go and they took the video of the house. So they had they have a source for what the house looked like. So we got Xana exit from kitchen, hallway, look around model, hallway, look around number model, exit Xana, Bethany, Dylan, Ethan, Kaylee, Madison, Xana timeline, Slavinsky, 11/13/22, handoff, Slavinsky, Beat Cake Hall and VTM, Slavinsky, geofence report, Slavinsky, July 9th pool party, July 12th mountain hike. Cast final report analysis, AT&T breakdown data, Excel Wi-Fi status, Kohberger phone jury version, condensed version. Excel Wi-Fi status, Kohberger phone full. So this says the following items have previously been disclosed as exhibits by the defense. The defense intends to use these in the mitigation phase should the case proceed to a phase 2 in trial. So if he gets found guilty and they do the sentencing phase. So photo Pleasant Valley District Office, photo Pleasant Valley Security Office, photo exterior of his parents' house, photo of DeSales, 2 photos of DeSales, maternal genogram, paternal genogram, car accident reports, PA education writing reports, Bryan Kohberger report cards, statement from Kohberger family. That's interesting because I mean, they're using this if he's already found guilty for the death penalty phase or sentencing phase. Car accident reports. I'm trying to figure like where are they going with that for the sentencing phase. I get like the report cards and that kind of stuff. And the statement from Kohberger family, and I don't get the picture of or the exterior of their house. So, anyway, all right. So that's that. Here is the witness list. I forget, like, when I first started, I knew more names. I feel like when I was going through people and I was trying to figure out, like, students, but, now it's been so long and I don't know. I'm not going to know a lot of these. And a lot of them I might not even have known to begin with, but I know some of you guys that's really been studying this case, or I feel like more of the people that, think there's this big conspiracy. I feel like you guys probably know more of these names, but here's the witness list for This is witness list, state of Idaho, Ada County. So I don't know. I don't know if I'm going to name everybody, but let's see if there's anybody that sticks out. There's Allison Ackerman again. Emily Alliant. I'm surprised this wasn't all just black redactions. If you know what I'm saying, now that they're not redacting names anymore, it seems like it must have just gave up and realized. Chapin. I'm just going down. That's how I'm looking at it. And I go to this one. Let's see. Anybody that is sticking out that you guys think are interesting? I know, Kohberger sister is on there, which that doesn't really surprise me, to be honest. Amanda Kohberger right here. That's right, because this is the state's witness list, right? So some people were like, "Oh, look, why would this?" But yeah, I mean, sometimes they give the family, not that the family sometimes they don't want to do it, but they have to. There's that Donald McDonald, but they have to if they're subpoenaed. Dylan. I'm sure Bethany. I must have. Well, let me see. She's got to be. Oh, yeah, Bethany. I missed that. And Dylan, of course. That's not surprising. Shoot, I think somebody's delivering it. So that's what he's. Look, John Showalter. That must be his real name, his first name, and he must just go by Jack. Yeah. So that's a witness list. But anybody wants me to send it to him, if you guys want to go through it, it might be helpful down the road, when we're going through more documents, and maybe they'll say initials or something. We're like, who is that? And we could look up who it is. So it could possibly help us. I'll keep this, accessible. Okay. So this is the last one is that I have like interesting that I put under interesting. But there is more highlighted ones that I think we should go over more documents after this because we have time. Still early. So let's read this. Okay. So this is defendant's trial brief. Comes now, Bryan Kohberger, buying through his attorneys or records, submits this trial brief in anticipation of the jury trial scheduled to commence August 11th, 2025 at 8:30 a.m. with voir dire commencing on July 30th, 2025 at 9 a.m. The court set a date of trial briefing before each side has disclosed its exhibits. Given the 68 terabytes of unorganized discovery, the defense's inability to have it all reviewed, the ongoing disputes over incomplete expert opinion disclosures, and whatever exhibits the state list as those it will seek to admit at trial, this trial briefing is submitted in light of that background. The underlying alleged facts of the case are well known to the court and are not reiterated. Got indictment. A grand jury indictment, May 16th, returned against Mr. Kohberger for the charges of burglary, felony count murder, all the counts of murder. Okay. On June 26th, the state filed a notice pursuant to Idaho, providing the required notification of the state intent to seek the death penalty. Jury selection. Jury selection set to begin July 30th, 2025, will commence after jurors' questionnaires have been filled out and provided to counsel. The final juror questionnaire is yet to be determined. Mr. Kohberger has filed a motion seeking to prevent the use of the magic question. The magic question, what? And other procedures for jury selection. Mr. Kohberger filed a motion October 16th, 2024, requesting proper voir dire in his capital case. He reiterates his request for individual and sequestered voir dire as it relates to potential juror views on capital punishment as well as case-related information. Evidentiary issues. It is expected that issues surrounding relevance, remoteness, and complete defense will be raised throughout trial. Proof of alibi, alternate perpetrators. In the exclusion of expert opinions due to incomplete expert disclosures, will be an issue. In the exclusion of expert opinions due to incomplete expert disclosures will be an issue throughout the trial. In the various motions to compel, death penalty motions, suppression motions, and motions in limine filed with the court, many evidentiary issues have been raised. Such evidentiary issues include inflammatory evidence, prevent the introduction of inflammatory evidence such as irrelevant and unfairly prejudicial photographs, testimony, and exhibits is the subject of defendant's motion in limine number 1, re-inflammatory evidence. Mr. Kohberger contends that his right to a fair trial, free from irrelevant, cumulative, and unfairly prejudicial evidence as guaranteed by the state and federal constitutions, prevent the state from introducing evidence that cumulatively highlights gruesome exhibits or elicits overly emotional testimony. Mr. Kohberger heard the court's comments at the hearing with optimism, but will, if necessary, be ready to object and follow with a motion to ensure his trial is fair. Wait, hold on. This is on page 3. Hold on. I just want to see. What was this? This was the defendant's trial brief. Okay. Okay. I just wanted to see. Yeah, so this is his. I mean, the way it was reading this, I was pretty sure it's coming from the defense. Okay. All right. So now we're on number 2, excluding experts. Mr. Kohberger seeks to exclude expert testimony that is vague, undisclosed, and improper. Expert testimony and expert disclosures have been the subject of several motions, including defendant's motion to compel, material and for sanctions, defendant's motion to extend time to disclose defendant's guilt phase experts, defendant's motion in limine, vague and undisclosed expert testimony, defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Wait, what do they say? Expert testimony and expert disclosure have been the subject of several motions, including defendant's motion to compel material and for this. Huh. Yeah. All right. So it says defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Mr. Kohberger awaits the court's decision on his motion to exclude expert opinions due to the incomplete expert disclosures. And depending on the court's decision to exclude late, vague, and undisclosed opinions, these will be ongoing issues throughout the trial. Oh, I could make it a little bit bigger, huh? Sorry, guys. I never know how big. No, that's way too big. Oh. I actually pushed the wrong thing. Hold on. Okay. That should be good. No, that might be too big. I always like to get the perfect thing where it fits. Okay, so where are we at? We were at yeah, right here. So the defendant's motion to preclude the death penalty. Okay. Incomplete expert disclosures depending on the court's decision to exclude late, vague, and undisclosed opinions. These will be ongoing issues throughout the trial. Murder terms. Let's do it like that. There we go. Use of the words murder, murderer, murdered, murder weapon, and similar forms of the word murder applied to Bryan Kohberger during the trial was the subject of a motion in limine. Mr. Kohberger understood the court's indication that labeling Mr. Kohberger murderer would be considered argument, and the proper place for argument is in closing argument. Mr. Kohberger is optimistic the case will be tried in accordance with the court's statements, but will be ready to object and follow with an appropriate motion to ensure his fair trial. Psychopath, sociopath terms. Use of the terms psychopath and sociopath is subject to defendant's motion in limine number 4. Using the term psychopath or sociopath, Mr. Kohberger understands the state has no intention of utilizing such labels. Mr. Kohberger is optimistic the case will be tried without the use of such terms. He will be ready to object and follow with an appropriate motion to ensure his trial is fair. Inconclusive data. Inconclusive data about the statistical analysis of item 13.1, fingernail scrapings, is the subject of defendant's motion in limine number 5. Inconclusive data, Mr. Kohberger has now reviewed the state's newest expert disclosure, and based on the work of both the state's expert and his own expert, he has been excluded as a source of DNA. Testimony about the lab testing must comport with both experts. With both experts reviewing the sample and opining Mr. Kohberger is excluded. Wait, so it says testimony about the lab testing must comport with both experts reviewing the sample and opining that he's excluded. Mr. Kohberger understands the state's position to now be that the evidence does in fact exclude Mr. Kohberger as a source of any DNA. In sample 13.1, testimony contrary to that would violate his federal and state constitutional rights to due process, fair trial, and would be falsely testimonies. And they're not talking about the sheath DNA. They're talking about the other DNA that was found under the fingernail. Oh, I guess they do describe it. It's under the fingernails, so I didn't have to point it out. Sorry, I forgot. Man, I'm finding that's another thing. I get those cramps, and I don't know why they don't come at night. It's always in the daytime, and I'm starting to get it where I have to lay down. With like the week leading up to my period. Oh man, I hope it passes. Because all week all the last 3 or 4 days I had to go lay down. I forgot about that. Okay. Just try to. I don't want to have to do that. I'm gonna finish this. Okay. Try to block it out. Maybe power of mind. Touch or contact DNA. Testimony of Rylan Nolan and any testimony referencing the terms touch or contact DNA, or that purports to be an opinion of the means or mechanism for DNA being placed on the sheath by any witness called to testify about DNA was the subject of defendant's motion limine 6. Wait. That purports to be an opinion of the means or mechanism for DNA being placed on the sheath by any witness called to testify about DNA was the subject of defendant's motion. Okay, Rylan Nolan and the reference touch and contact DNA. Mr. Kohberger sought to exclude any use of the language touch and contact in the context of the DNA testing of the sheath and any opinion of how and when the DNA on the sheath was deposited. Hold on, let me see something. Okay, so I know they want to take that language out because when you hear touch DNA or contact DNA or whatever, then you know, you're picturing somebody touching or contacting or and which I mean, it would have to be that. But they want to take that wording away and because because it could be never mind, it could be from a what do they call that? What's the word for that where somebody else could oh my god, I can't even think of the word, but let's say like I get DNA from this and it's like Zeke's, you know, and I'm the one that passes it on. So I'm the one that touches the sheath. But I have Zeke's DNA on me and then you know what I'm saying? What is the word? So they don't want it to appear that the touch DNA means 100% that Bryan touched the sheath. So they're trying to like create reasonable doubt that maybe it could have got on there a different way if somebody else came in contact with Bryan's DNA and then they touched the knife sheath and then it got on there. What is that word? Why can't I think of the word? Oh, thanks, Smashing Blouse. Thank you. Thank you so much. Transfer. That's what I was thinking of. Transfer. Thank you, Cease Through. That's exactly the word I was thinking. Oh, sometimes I just can't think of words in the moment where I'm like, I can't think of it. Thank you. And thank you, Smashing Balls. Okay. So it's saying that yeah, because they did the sheath and any opinion on how and when the DNA of the sheath was deposited. So they want to um wait, where are you at? To exclude any use of language in the context of the DNA testing of the sheath and any opinion of how and when the DNA on the sheath was deposited. While the court did not enter an order excluding the language, the court's suggestion that it should not be used to avoid confusion and prejudice to Mr. Kohberger is well taken. His objection will be lodged during trial should the use of the phrase come up. 7. Bushy eyebrows. Witness identification by bushy eyebrows is the subject of the defendant's motion in limine 7. Re-witness identification by bushy eyebrows. Mr. Kohberger sought to bar witness DM from using the word bushy eyebrows or identifying him in that manner. He also sought to keep the state from acting as an identifying witness by attempting to bolster DM's testimony with a photo of Mr. Kohberger taken the morning of November 13th, 2022, in arguing that it is their interpretation that the bushy eyebrows described by Dylan are consistent with those in the photo. Should the court allow this testimony and procedure, Mr. Kohberger will object during trial. Evidence has been the subject of a notice, a motion, and a stipulation, including state's notice of intent to use IRE, defendant's motion in limine 8, unnoticed 404B evidence and sealed stipulated agreement of the parties to not mention 2014 cell phone incident during trial. In response to defendant's motion in limine number 8, the state has advised the court and counsel that it intends to comply with the application of the Idaho rules of evidence in regard to any proposed IRE. Additionally, in a sealed stipulation, the parties agree not to mention the 2014 cell phone incident during trial. That incident involved Mr. Kohberger's taking his sister's cell phone to a kiosk at a mall in exchange for money. His father called police, the end result of which was a minor theft charge that was later expunged. The state has not indicated 404 evidence, 404B evidence other than a traffic stop. Mr. Kohberger will object and follow with an appropriate motion any other act evidence. With an appropriate motion, any other act evidence the state seeks to introduce that is unnoticed. Okay. Okay, so Mr. Kohberger will rely on State versus Whitaker for the proposition that although Rule 404 has its genesis in the common law rule that the doing of a criminal act not part of the issue is not admissible as evidence of the doing of the criminal act charged. The rule expands this evidentiary bar beyond evidence of other crimes. The inclusion of the words wrongs or acts prohibits the evidence of conduct beyond criminal offenses if it is proffered for the purpose of showing a person's character and conforming behavior. In Whitaker, the court held that 404B is not limited to bad acts. In the State versus Pena, the same appellate court said the other act evidence to prove a person's character and conforming behavior falls under 404. Okay. Amazon click activity, excluding Amazon evidence, purchase history, and Amazon click activity. Collectively, Amazon evidence was the subject of defendant's motion in limine 9. Excluding Amazon click activity evidence at trial. The state's methodology in obtaining, using, and producing Amazon evidence has been called into question by Mr. Kohberger, who contends that this evidence should be excluded. To the extent that the court allows the evidence, Mr. Kohberger must be able to present expert testimony of David Howe to provide a complete defense. Based on the court's ruling, that this evidence will not be excluded at this juncture. Mr. Kohberger will confront the evidence through expert testimony. He will also object to any expert opinion testimony by Mr. Shane Cox or S.A. Michael Douglas, as the state claims they are lay witness and not experts. Investigative genetic genealogy, we'll just call it IgG, evidence has been the subject of at least 6 motions, including defendant's 3rd motion to compel, defendant's 5th motion to compel discovery, defendant's 7th motion to compel, defendant's motion to suppress, genetic information, state's motion in limine, IgG, and the defendant's motion in limine 11, exclude IgG evidence. The state's methodology in obtaining, using, and producing IgG evidence has been litigated through discovery and motion to compel, and finally through motion to suppress. Mr. Kohberger learned of undisclosed discovery during the suppression hearing and was refused access. Refused access. Wait, what? Oh, to the undisclosed discovery. Okay, yeah. As such, Mr. Kohberger contends that IgG evidence should be excluded because he could not fully understand and litigate the issues. At this time, the state has agreed to proceed without use of the IgG evidence and introduce evidence of a generic tip. Both sides are working towards an agreed upon special jury instruction on the tip evidence to avoid speculation by the jury as to the source and nature of the tip. Oh, guys, it's getting hard. Usually I have to lay down and it's like such bad pain. Every other month is worse, you know? So I think it's like one worse ovary. I know men probably don't want to hear this, but like, so every other month. So the last month wasn't as bad, but this, oh my God, I hope I get, hold on, let me just, I don't want to have to stop this. I want to finish these. Okay. Vehicle identification, exclusion of the state referring to all surveillance footage they intend to offer as suspect vehicle number 1 was the subject of defendant's motion in limine. Make and model of suspect vehicle Mr. Kohberger sought to exclude this evidence pursuant to specific rules of evidence and based on his federal and state constitutional rights. His motion was not directed to the testimony of the state's expert, SAML, but rather to exclude the state from arguing and other witnesses from saying that all depictions of vehicles were the same vehicle. Based on the court's questioning, Mr. Kohberger must be able to explore with SAML the year range he was most comfortable with based on the 1125 Ridge Road footage, which videos allowed identification of makes and models, and which videos caused him to focus on 2014 to 2016 years. The actual evidence provides a less clear trail. Mr. Kohberger, in exercising his confrontation rights, must be allowed to explore SAEML's opinion. Take some water. Autism spectrum disorder. Mr. Kohberger's autism spectrum disorder, along with related issues, was the subject of 3 pending motions. Defendant's motion in limine 13, conditions as aggravator, state's motion in limine neuropsychological and psychiatric evidence, and defendant's motion to strike death penalty, re-autism. Mr. Kohberger anticipates that the issues related to ASD will arise throughout trial, with continued effort by the defense to explain ASD and provide defenses related to the state of mind. Statistical analysis and related testimony were subject of the defendant's motion in limine. Statistical analysis, Mr. Kohberger sought an order preventing the state from improperly eliciting statistical testimony. Allowing such testimony would violate his federal and constitutional rights to due process, fair trial, effective assistance of counsel, and confrontation of witness. The state has agreed that they will not elicit testimony attempting to relate the likelihood ratio for the DNA on the sheath to the world population. Recording, 911 recording and transcript. The recording and transcript of the 911 call to the Whitcomb on November 13th was the subject of the sealed state's motion in limine re-911 call. Relying on exceptions to the hearsay rule and the effect on listener, the state seeks the omission of both the transcript and the recording. Based on his constitutional rights, Mr. Kohberger objects to the admission of the transcript and the recording. I don't know why he would not want that. It doesn't really make him look more guilty or innocent than the 911 call, right? I don't know. Alibi evidence is the subject of various notices, discovery responses, and motions. On July 24th, 23, Mr. Kohberger filed his notice of alibi. Pursuant to court order, Mr. Kohberger filed a notice of defendant's supplemental response to state's alibi demand on April 17th, 2024. Previously, Mr. Kohberger's alibi has been the subject of a motion to compel. More recently, the state filed a motion in limine, re-alibi. Mr. Kohberger has met his statutory obligation of provide the state notice of corroboration of his partial alibi. Mr. Kohberger stated on record his concern about the state commenting on his constitutional rights to remain silent. He will make an appropriate motion should these comments be made in front of his jury. Alternate perpetrator. Alternate perpetrator evidence is the subject of the state's motion in limine. Alternate perpetrator evidence. Mr. Kohberger anticipates making a proffer of evidence of alternative perpetrators so that such evidence can be properly evaluated for relevancy and admissibility under the Idaho Rules of Evidence. Mr. Kohberger's notes, as did the court during the hearing, that those investigated do not all meet the factors required to be offered as an alternate perpetrator. Mr. Kohberger's interpretation of the court's comments is that persons investigated by the state may be confronted through cross-examination of law enforcement investigative work. Demonstrative exhibits. Demonstrative exhibit, the 3-dimensional model of the King Road house, dollhouse, was the subject of the state's motion in limine Mr. Kohberger will continue to object the use of the dollhouse for distinct reasons arising from discovery issues. Specifically, Mr. Kohberger objects to the use of the three-dimensional model house constructed in an undisclosed way on the grounds that it is irrelevant, prejudicial, cumulative, confusing, and misleading to the jury. Did you guys see those pictures of him? I have the pictures of the dollhouse. Have you guys seen it? I gotta find it in my files. It was released a while ago, but I never ended up sharing it. I don't think because by the time I saw it, it was already out for a while. So I figured you guys most people seen it, but I shouldn't always assume because I'm sure there's some people that haven't. But their little model house, I'll get it here a little later. Family and courtroom. Family in the courtroom is the subject of the state's motion in limine. Immediate families in the courtroom. Mr. Kohberger stipulated in his brief responding to the state's motion in limine that the individuals identified by the state be considered as immediate family. Wait, what? So wait, family in the court is subject to state's motion in limine. Individuals identified by the state to be considered immediate family of the victims for purposes of being in the courtroom during trial. So he's saying he stipulated in his brief responding to the state's motion in limine that the individuals identified by the state be considered as immediate family of the victims for purposes of being in the courtroom during trial. In his responsive briefing, Mr. Kohberger also asked the court for guidance on proper courtroom decorum and guidance on excluding clothing or anything worn in a gallery that supports the death penalty, and asked that Mr. Kohberger's family members have presence in the courtroom. The state represented to the court that it had no intention of using its subpoena power to exclude Mr. Kohberger's family. The court asked the state to determine which family members it intends to call. Work with the defense and call the person out of the order, or call the person or persons out of order so that Mr. Kohberger's family could be in the courtroom. That hearing was on video. I watched it. I think I live streamed it, where they talk about that, and he talks about, well, just, instead of, the state was like, well, then it'll mess up like the flow of how we're trying to present the information. But then the judge ruled it, well, no, then just, you have to do it out of order because they deserve to be in there, because they're not allowed to be in the trial until after their testimony. So if they had the order, let's say one of the family members was at the end of the trial because they didn't want to call them until like the end of the witness list, then they would not be able to see that whole beginning of the trial. So the judge ruled like, no, just call them out of order, get out all of them at the beginning, so then they're able to watch the rest of the trial. Okay, so death penalty. The death penalty and issues related to the death penalty have been the subject of various motions. Such motions include 13 separate death penalty motions with the topics ranging from arbitrariness to utter disregard. Sealed state's motion in limine and proper death penalty comments. Defendant's motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Defendant's motion to strike death penalty, re-autism. Most of these motions have been decided while others are pending. Mr. Kohberger anticipates that the issues related to the death penalty will arise throughout trial, with continued effort to get the death penalty stricken. Self-authenticating records. Self-authentication of records was the subject of the sealed state's motion in limine. Self-authentication of records and reliance of IRE. In its motion, the state seeks to admit self-authenticating records. The list of records that the state seeks to admit in this manner is lengthy, and the volume of data is enormous. Mr. Kohberger has objected to giving the state a free pass for the admissibility of records that are supposedly self-authenticating. After expending extensive time responding to the state's extensive request for self-authentication of records, the state abandoned nearly half of its requests. The court noted the motion was not ready for hearing. Mr. Kohberger will make objections and motions as appropriate. Um, Text messages and testimony. Text messages DM Dylan on November 13th and testimony of Dylan and Bethany regarding their conversation with each other on November 13th are the subject of the sealed state's motion in limine. Text messages and testimony. Mr. Kohberger contends that the way in which the state proposes using the text messages and testimony presents an incomplete picture. Mr. Kohberger has urged the court to view the state's request with consideration of the complete scope of conversations and cell phone activity and deny the state's motion. AT&T timing advance records. In the state's motion in limine, AT&T timing advance records, the state seeks to prohibit the defense from making any reference to the absence of AT&T timing advance records for Bryan Kohberger. The defense contends that TA reports relating to Kohberger's cell phone exist at least 7 days of record. Mr. Kohberger has been provided with different explanations by the state regarding the existence of these records throughout the course of his case, including sworn testimony in May of 2024 by Detective Payne. Mr. Kohberger has offered testimony relating to these records based on explanations presented by the state. Wait, so they offered testimony? Hold on. Mr. Kohberger has offered testimony relating to these what records are we talking about again? I forget. The AT&T records. Okay, so offer testimony relating to these records based on the explanations presented by the state. The current defense affidavit presented at the in limine hearing is one with more detail and based on the shifting state explanation. So the current Mr. Kohberger has worked with an expert with hands-on experience about TA records. He was not allowed to testify and explain what he knew about the methods officer used in obtaining the TA records. Mr. Kohberger understands his ability to question the FBI agent outside the presence of the jury. Warrants. Warrants have been the subject of at least 13 suppression motions ranging on topics from the arrest warrant to the search of Mr. Kohberger's apartment in Pullman. While the court has already ruled on these suppression motions, Mr. Kohberger anticipates the evidentiary issues related to the various warrants will be raised during trial in the form of inconsistent statements or the impeachment of the state witnesses. Additionally, the state obtained similar information through the grand jury subpoena process. Mr. Kohberger was prevented from receiving copies of the actual grand jury subpoenas. Oh, hold on, let me go up. And therefore does not know the scope of information obtained. He will make objections during trial based on the rules of evidence. Investigators in the courtroom. The parties have stipulated and agreed that the defense will have both of their investigators present during the trial and that the state will have its lead investigators from Moscow, Brett Payne, and the Idaho State Police, Darren Gilbertson present during the trial without limiting their ability to testify. So, without limiting, okay. Exhibits. In compliance with the modification of the court's scheduling order, Mr. Kohberger proposed exhibit lists will be filed and provided to the state by April 28th, 25. While Mr. Kohberger is making every effort to meet this deadline, all discovery has not been reviewed. The 68 terabytes of discovery is unorganized and overwhelming, and the court has ordered the exchange of exhibits to be disclosed 1 week apart. The state's expert disclosures are incomplete, and it is expected that subsequent exhibits will be identified and disclosed beyond the court's April 28th deadline. Witnesses, expert witnesses. Mr. Kohberger had disclosed exceedingly comprehensive expert reports and opinions. The alleged facts are going to be very heavily contested issue by issue. Mr. Kohberger does not intend to put on a very extensive defense case. He anticipates calling the following expert witnesses to testify at trial, depending on the state's case in chief during the guilt phase of trial. Ruth Ballard, PhD, Stephen Becker, Kathleen Bright, Burn Mom, David Howell, Matthew Nodell, Rachel Lawson, PsyD, Carol Peden, Kevin Peden, Jennifer Horniak, Bracamontes, Cy Josiah Roloff, Eileen Ryan, Gary Shuttler, Thomas Slovensky, Brent Turvey, Barbara Wolf. Barbara Wolf is the one I was trying to, or wait, no, not Barbara Wolf. What was the, why can't I think of the name of the, his professor that did the interviews? Hold on. Let me Google that. No, it's just Ramsland. Well, wait. I swear they said she was gonna be on the witness list for him. Oh, that's the expert witnesses. So hers would be, well, wouldn't she be? No, because she wouldn't be never mind, because she wouldn't be talking as an expert witness. That's Ramsland. Okay, so I gotta remember that. You're saying all lies, George. I'm just reading the documents that got released. So what are you talking about? I'm reading the documents. Why are you saying all lies that I'm saying? I'm not even giving my opinion. I'm reading the freaking documents. How could it be all lies? I'm just reading. I'm doing what I'm claiming to do. New documents got released. I'm going to read them to you for the case. I mean, what the heck? Chill. Okay. But why isn't Ramsland the? I thought she was a witness. Would that be a lay? Oh, yeah, that's what I came to conclusion. She wouldn't be considered an expert witness if she was a witness for him. That's right. Okay. All right. So lay witnesses. Lay witness that Mr. Kohberger anticipates calling to testify during the guilt phase of the trial will be disclosed by defendant on April 21st, 25. Okay, I get it. I see, George. Okay, I misunderstood. I thought you said all lies, Zab. I thought you were saying I was saying all lies. Okay, I got it. I see. I misunderstood the message or the text. Sorry. Okay. Lay witness. Mr. Kohberger anticipates calling to testify during the guilt phase of the trial will be disclosed by defendant April 21st, 25 by filing a witness list under seal in compliance with the court's scheduling order. But George, I mean, you hear me when I'm saying I get it. Sorry, I misunderstood your message. Anybody else new I should say? Oh, hi, Nina. Anybody else new that came in? I say hi. Brian, I already said hi to you, I think. Take a nap that we can call. No, actually, it went away. I think keeping my mind busy and just think like knowing, okay, I have to do this. I'm going to just mind over matter. Normally, it gets so bad I have to lay down, and I'm laying down, I'm curled up in a ball, and I'm like, oh, it's so bad. But somehow my mind made it pass. I don't know how I just did it, but I'm not going to complain. um, It's okay, George. Yeah. I misunderstand a lot of text because I'll like be reading and I look in the messages and I sometimes I think people are talking to me and they're talking to people in chat, or I misunderstand because I don't have the context. I'll try to scroll up sometimes, but yeah, no, you're okay. Um Okay, so lay witness. So where are we at? So defendant on April 21st, 25 by filing a witness list under seal and compliance. Okay, so where are we at? So to the extent other witnesses are identified as 68 terabytes of discovery are reviewed, the list will be supplemented. Penalty phase lay witnesses will be disclosed by Mr. Kohberger on May 5th by filing a witness list under seal and compliance with the court's scheduling order. Investigation for the mitigation phase of the trial, if this case proceeds that far, is ongoing. The mitigation investigation began immediately upon Mr. Kohberger's arrest, but it has been extremely difficult to get teachers, medical providers, family, friends, neighbors, coworkers, and others to speak with the defense team. Generational records are still being located and gathered. As people and records are located, those will be disclosed and witness lists supplemented. Okay, so that's that. I'm debating if I want to take a quick break and play that. Let me play Olivia's TikTok. Because the interview is like 30 or 40 minutes that she does with Brian Etten, which I do think if I feel like it after I read the rest of the documents, I'll play that. It is interesting. I listened to it last night. But let me play her TikTok is quicker. And then I'll look for those pictures of that dollhouse I wanted to show you if you guys haven't seen it. Let me type in TikTok. Oh, actually, you know what? It might be easier if I go to my Gmail because I get TikTok notifications in my Gmail. All right, yeah, that'll be easier doing it that way. Okay.
Yeah, I got a question.
Wait, why didn't I go to hers? Hold on. Go to hers.
So I have to keep this.
Okay. Oh, I forgot to do the live. I want to. You guys remind me next time. I want to, since I have Rumble and now I can go live on TikTok, I want to stream to all of them at the same time. Might as well. I keep forgetting. Okay, so here we go.
It's really brief, but in regards to some descriptions of autopsy photos that the state had planned to introduce as exhibits, I just wanted to offer a little bit of my perspective that maybe will help lessen some of the speculation. I need to be very clear. I'm not talking anything specifically about Maddie, about Xana, about Ethan. I don't know anything specifically about them at all whatsoever. So I can only talk to my experiences regarding Kaylee's autopsy and questions that I've had for investigators and everything like that. So I just want to make that really clear. And there's really no easy way to say this. The gag order protected an absolute fucking monster. It's disgusting, but some of the wounds that were made to Kaylee were described as experimental. So a wound that might typically, in its presentation, look defensive, might not have necessarily been defensive because at some point he was inflicting wounds that, I mean, any logical person would know wouldn't be fatal. So I don't want to speculate on, what exactly he was doing, whether it was to, just cause pain or whatnot. But yeah, these wounds didn't necessarily make a lot of sense. They were described to me as experimental, and on Kaylee specifically, there was evidence that he continued the attack after she was no longer even fighting back. So just in light of that, just because there's a wound on a hand or a wound on a forearm or a wound on a wrist, these really, really classic defensive places, unfortunately we just can't make that assumption. And even if they were, the body reacts and there's reflexes to protect your face, your head, your neck, it doesn't mean that someone wasn't sleeping beforehand or was just briefly woken. So yeah, yeah. And also I want to add just really quickly, I don't want to fucking be doing this, but no one on the state side is standing up and giving details like this. And I get it to some extent, but it's creating like massive amounts of chaos. And I'm tired of ignoring it. So yeah.
So, it was late at night or early in the morning. So it seems likely that maybe they were sleeping.
Sorry.
Okay, so that was her TikTok she did the other day, one day ago. I think it was yesterday. Okay, so I wanna show, since I said I would show that dollhouse. I'm sure most of you guys have seen it, but oh my god, no, it's the wrong one. Sorry, hold on. Okay, so here's the pictures of the model home they had done. What is it? Oh, did it not to scale? I still don't understand like why it would have been that, like they said it would just have been too much to have it scale, but I mean they're taking the time to build it. Why not just do the dimensions of the house and make it to scale? That's what I never understood. Why would it have been that much extra to just do it in the dimensions of the house rather than just, you know what I'm saying? I mean, it looks like it, but everything isn't exactly to scale, they said. Huh. And then when you take it off, you can see that was Kaylee's room. Kaylee's room is the one that had the patio. I mean, it went over all the way to Maddie's room, but Maddie didn't have a door in her room to go out in it. But look how much smaller her room is than, well, I guess never mind, it's not to scale, so probably the bathroom and then Xana's room, living room. So that's it. Okay. So let me go over the other documents, some of the other ones. We actually got through a lot of them. There's still quite a few left, but at least I want to get ones. I have 10 in the folder as like boring, kind of like either repetitive or kind of boring ones. So I'm probably not going to go over those, but I still do have There's 2, 4, 5 that go over like what request to what to be sealed and what to not be sealed. So I mean, maybe if you guys want to hear those in another live, but right now I'm going to go over ones that I put in that are like more interesting. So I have 1, 2, 3, 4, 5, 6, 7, 8, like 8 more to go over. That I felt could be kind of interesting to go over. Okay, so let's see here what we have. This is state's motion for an exam, defendant pursuant extension of time. Hold on. I think one of them is like repetitive because sometimes if they have like, you know, a rebuttal and then they have the what they're rebutting, it's like repetitive stuff because they just kind of like go over. There might be some points they point out, but so that's why I'm trying to avoid some of that repetitive stuff. So this, hold on 1 second, because there's one that's on the ceiling. Hold on, in support of. Let's just start to read some of this. Okay. I'm wasting time trying to figure out which ones are which, so I might as well just read them as I go. Okay, here we go. So this is undersigned submits a reply in support for an examination of defendant and for an extension of time to complete rebuttal penalty phase expert disclosure. Actually, I could probably do 225 on that. There we go. That should be good. Okay. Introduction. The state seeks the opportunity afforded to it by Idaho to rebut defendant's mental condition expert witness testimony. Defendant seeks to prevent this. He misconstrues the nature of the state's expert proposed neuropsychology examination. He seeks to insert his counsel in the middle of the exam process, and he claims the motion is untimely because the state should have raised this penalty rebuttal issue even before the defendant's own penalty phase disclosures were due. In essence, the defendant seeks to nullify Idaho code. The court rejects his arguments and grants the state's motion. Argument. The state expert's proposed personality testing is proper. The state psychology expert proposes to include limited personality testing in his neuropsychology examination of the defendant. In his declaration, the state psychologist explains why, in his professional opinion, this is important. Personality testing is a way to validate or rebut both the reliability of how defendant presents himself and his underlying diagnosis, especially autism. Defendant does not directly address the state's psychologist's opinions and has not offered a declaration from his psychology experts to contradict the state's expert. Instead, defendant sidesteps the issue with two misplaced arguments. First, he claims that the personality testing is not proper or rebuttal because it is outside the scope of what his own experts explored. This is wrong. Like the defendant's expert, the state's expert will perform a neuropsychological examination focused on autism and OCD. The scope of the examination will remain neuropsychological. The state's expert will just use additional methods to complement and supplement those used by the defendant's experts. The battery test would serve to supplement the battery that Dr. Orr completed and provide some additional valuable information. In this way, the present dispute is about the manner of the examination, not its scope. The defendant glosses over this distinction by citing cases in which the prosecution sought to explore the new diagnosis or mental health conditions. So this state in some cases where they're saying like, there should be no rebuttal. I mean, they should be able to do this because they're just kind of they're only using the same things as what the defense is bringing up. They're not like trying to re-diagnose or add different diagnoses, but they're using the same ones that he is bringing up in his defense as of autism and OCD and stuff. So they're not like giving him a new diagnosis or anything. Okay. I guess I could read some of this. So the defendant has a traumatic brain. Oh, so no, they're just bringing up other cases. So yeah, that's not specific to his. Okay. The court in those cases limited the prosecution because the proposed examination sought to establish new mental conditions. So the cases that the defense is bringing up as arguments, it's like, no, those don't fit because those cases are establishing new mental conditions. We're not. We're just doing the same ones that you are bringing up in your defense, allowing personality testing to the extent and contain testing scales for they bring it up in that case. Okay. But unlike in defendant cited cases, the state's experts proposed personality testing will remain focused on the same mental conditions diagnosed by defendant's experts. Thus, the court should not limit the state's experts' testing choices because they have necessary nexus to the defense experts' findings and are reasonably tailored to the evidence it seeks to refute. Second, the defendant claims the personality testing would violate his Fifth Amendment rights against self-incrimination. This concern overlooks the plain language of, by putting his mental health at issue, the defendant knowingly waived any privilege he previously held to preclude the state's expert from conducting an independent evaluation. The entire purpose of 18207 is to prevent a party from taking the position of the defendant now takes, that he can put before the jury mental health evidence that has not been fully subject to the adversarial process. The defendant's concern is overstated. He isolates certain questions from the MMPI that he argues call for incriminating responses, but the current procedural posture is important. Purpose of the requested examination is to rebut mitigation evidence during the penalty phase, not to address guilt, and certainly not to seek admissions relevant to guilt. It is also important to note that questions and assessments are not specific to the case. The answers to them will be analyzed by the state's expert psychologist to inform the opinions in his written report. So yeah, I mean, so in other words, because the function of the personality assessment is to evaluate defendant's mental conditions, not to create testimonial evidence to be used against the defendant, personality testing is appropriate. Okay. And they're saying they'll have an opportunity to object. Okay. So 2, defendant's counsel should not be present in the examination room. Based on its expert declaration, the state requests that only its retained expert psychologist and defendant be present in the room during the neuropsychological exam. This comports with standard psychology practice, as demonstrated by the fact that counsel was not present during the defense's expert examination of defendant. I'm going to just skip through some of this because I'll cite in other cases. The court should grant the state its requested extension. State seeks an extension of time to make its rebuttal. Penalty phase expert. So its expert can conduct the exam and prepare his report. 21 days after the exam is completed. Defendant objects on 2 grounds, both of which court should overrule. So yeah, do you guys want me to read it? So one of the ones there, the defendant argues that the state has not shown good cause for the extension because defendant disclosed mental condition expert reports in January, which he believes should have prompted the state to make its own motion, but does not contain a deadline to seek an examination, and the defendant ignores how the scheduling order is in this case was set up. Defendant's penalty phase expert disclosures were due March 31st, 25. State's rebuttal disclosures were due April 28th, 25. The state was entitled to wait until the defendant made his disclosures to determine which experts is needed for rebuttal and whether a 18207 exam would be necessary. And the defendant disclosed 3 other mental condition expert reports today. So state has acted diligently. Prior to the defendant's disclosure, the state had retained a psychologist and it requested exam 2 days after defendant's disclosure with weeks to go before its rebuttal deadline. Says perhaps the state should have anticipated that the instant disputes would arise and delay examination, but in no way waived its right. Good cause exists for the requested extension given the volume and nature of the defendant. Okay. All right, so let's go to the next one here. So this is about sealing and unsealing stuff. Order unsealing, redacting, or maintaining sealed status. The court issued an order seeking the parties' position regarding the sealing and unsealing of documents identified therein. Okay. Documents to unseal. With regard to the following documents, the court received no objection to either party or by either party to their unsealing, and court finds no further justification warrant their continued seal. That's right, because they go over why, like, the unsealing and sealing. Is there a need to keep sealing stuff, or but that would be more redacting, right? Well, I guess some of them could be unsealed but with redactions. So let's see what it says. 53025 parties proposed stipulated jury instruction. So this is warrant. They find no further justification to warrant their continued sealed status. So they're going to unseal these. There's no reason to continue sealing. And most of them is what we got, right? They unsealed them and now we have them because they already went through these ones. Let's see. Parties proposed stipulated jury instruction. States proposed supplemental jury instruction. Objection to the court's request for defense to submit a redacted copy of ex parte filing. Exhibit F to defendant's 6th supplemental response to discovery. Defendant's objections to the jury question. We read that. Court minutes, closed session. Second notice of filing defendant's proposed jury instructions. Amended exhibit list and motion to seal. So that's unsealed. Parties joint proposed jury instruction. Okay, a lot of the jury stuff. State's response to defendant's proposed jury. Okay. Which there's some more that, a lot of repetitive stuff. That's why some of them I put in as boring. So that's why maybe you'll see some that we didn't go over. But we still have some that I do want to go over. So a bunch of jury stuff. Okay. AT&T time in advance. With regard to the following documents, the court received objection by one or both parties to their unsealing. However, after considering the objection, the court finds no further justification. So the first one is they both agreed, right? No objection to either party to seal these. So both say no, that they don't need to be sealed. This next list, it says either one or both were objected to unsealing these. So one or both wanted to keep them sealed. So let's see. But it says, however, after consideration, the objections, the court finds no further justification under blah, blah, blah to warrant their continued sealed. So the judge is like, nope, it doesn't need to be sealed anymore. So we have Exhibit S2 to state supplemental rebuttal disclosure, penalty phase experts. So the experts penalty phase, state supplemental rebuttal disclosure, penalty phase expert. Exhibit S1, the state's motion to reclaim exhibits, court minutes sealed, reply in support of state's motion for exam of defendant, extension of time, defendant's objection to state's motion for exam, gauge declaration in support of motion for exam, state's motion exam, okay. State's exhibit list, state's witness list, defendant's second response to exhibit S1, so exhibit E to defendant's supplemental response discovery, state's trial brief, defendant's trial brief. So we read, which one did we read? We read one of those. I think we just read it. It was shoot, I forget. We just read that, a long one. Was that the state's or the defendant's trial brief? Defendant's response to the state's first supplemental request, transfer of test materials, Exhibit S1 to state's first supplemental request for discovery. Okay. Documents to maintain sealed status. So this is kind of interesting. So what they're saying, these are ones that they're going to maintain being sealed. Okay. With regard to the following documents, the court received objection by one or both parties to their unsealing. Having considered the objection, the court agrees that their sealed status shall be maintained pursuant to. Actually, I feel like the highlighting makes this more annoying to read, huh? Let me see, because I could turn it off, but let me see. We're on page 3. Let me see how much. If I should keep it, because if it's all like highlighted, I might as well just. Yeah, I could undo it, because doesn't it make it harder? I feel like it makes it harder to read, right? Okay. I don't like how it does it in blocks. Or do you guys prefer it? Whatever is easier for you guys. Hi, piano. Um, all right, so all right. Sorry, just making sure everything is good in chat. Okay. And just seeing if anybody had a response, if you guys like it better with highlighted or not. Okay, documents to maintain sealed. Okay. So it says the court agrees that they're sealed. Status shall be maintained. Okay. Exhibit S1 state supplemental rebuttal disclosure penalty phase experts. Okay. This document contains sensitive and detailed confidential mental health information of defendant and other individuals that has not been publicly disclosed. The release of this information into the public realm would be highly objectionable to a reasonable person, which outweighs the public's right to access. Thus, they shall remain sealed. Defendant's evidence in support of proof alternate perpetrators. This document contains numerous references to the names and other personal identifying information of proffered alternate perpetrators that could be used to identify them, the publication of which would be highly objectionable and reasonable to a reasonable person. To preserve their privacy, continued sealing is appropriate. Proof alter. I agree. That's when I highly agree on it, because they were gonna basically put out other people, possible people they think committed this murder, right? And then like that could be taken as, some people take it as, oh, that means they're guilty and they all those innocent people. Yeah, so I get that. Okay. Where are we at? All right. And then we have court minutes closed. So let me make this one more bigger. Oh, that's right. I keep forgetting 225. Okay. Court minutes closed session. The document references discussions between the court and the parties regarding the potential leak of information in this case, which subsequently resulted in an investigation. This information is exempt from disclosure. And then we got defendant's offer of proof alternate perpetrators. The document is replete with personal, intimate information about proffered alternate perpetrators. that could be used to identify them, in the publication of which would be highly objectionable to a reasonable person. To preserve their privacy, the court finding sealing appropriate. Exhibit D to defendant's forced supplemental response to discovery. This document identifies medical records for individuals other than the defendant. The release of this information into public realm would be highly objectionable to a reasonable person, which outweighs the public's right to access. Thus, they shall remain sealed pursuant to. Huh. Wonder what people it has their record or their information. Notice read defense expert disclosure. Exhibit D7. This document identifies certain mental health information that's private and protected under, therefore be exempt from disclosure. Further, the release of this information will be highly objectionable to a reasonable person and shall remain sealed. Now we have documents to unseal and redact. With regard to the following documents, the court received objection by one or both parties to their unsealing. Having considered the objection, the court finds no further justification under ICIR to warrant their continued sealed status, but redactions are necessary to balance the public's right to access with privacy concerns implicated. So these are the ones they're going to unseal, but they're going to redact. Okay. Defendants amended phase 2 mitigation witness list. So the mitigation witness list. So after that would be after if he got found guilty in the sentencing phase is when the mitigation witness list would come up. It'd be those witnesses, right? This document identifies the names and addresses mitigation witnesses identified by defendant. The primary concern voiced by both parties is fear that these witnesses will face threats or harassment if their names are publicly revealed. However, the majority of these witnesses whose names have been publicly identified have reported no threats or harassment. As a result, in the few that have are largely individuals who had a prominent role in the case. There have been no reported episodes of threats or harassment that have placed a witness's life or safety in danger. Consequently, the court does not find that being identified on defendant's witness list will lead to threats or harassment of such a degree to outweigh the public's right to access. Particularly given the time that has passed and the corresponding reduction in public fear, the public now has direct access to the most relevant evidence in the case. Thus, the need to chase down all potential leads is alleviated. While some of the listed witnesses may be contacted by the media and potentially harassed or threatened, this remote potential does not justify the continued sealing of the record. However, due to the fact that her health conditions may render her particularly susceptible to adverse effects from the potential of threats and harassment, the court orders that the name of the witness with the initials CE be redacted in favor of her initials. In addition, the court will redact the addresses of each witness pursuant to ICR. So these are the witnesses, defendant witnesses for the mitigation list, which usually that would be during the sentencing phase, right? After he'd be already found guilty. But it's the defendant's witness list, right? Okay. But it looks like they're going to unredact all the names except one of them because of some health condition she has and may render her susceptible to adverse effects and threats and harassment. So the initial C. Interesting. Okay. Defendant's phase 2 mitigation witness list. This document will be redacted consistent with 46. Wait, what? Oh, with this. Consistent with what this said. Okay. Her writ declaration in support of motion for examination. Support of a motion. Exhibits S3 and S4 to this document are reports issued by defendant's mental health experts containing confidential mental health information of defendant and other individuals that has not yet or has not been publicly disclosed. The release of this information in the public realm would be highly objectionable to a reasonable person, which outweighs the public right to access. Thus, these two exhibits shall be redacted in full pursuant to ICAR. Okay. The defendant's phase 1 lay witness list. Phase 1 lay witness list. This document will be redacted consistent with 46. Yeah, because remember, we got the expert witness list from the defendant. We just read, I think, the last document. But when they talk about the lay witnesses, they didn't give the list. Because remember, I was talking about if Ramsey would be on that or this. And I was like, no, she'd probably be on the lay witness list, but there was no witness list. Did I say her name right? Ramsey or whatever her name was, Ramsey or something. I forget. Ramsey, I think. Ramsey. It is Ramsland. I did say it wrong. It's supposed to be Ramsland. Okay. All right. So that's done. Cool. We are knocking them out. Knocking them out. Next one. Hold on, because I don't know if it's going to bring up my files. No, it didn't. Cool. I just saved it. All right. Next we'll do States Exhibit S1 to motion to reclaim exhibits. ES Business Record Affidavit, Grand Jury Exhibits 52, Sunset Martin Pullman Record Affidavit, Dylan Mortensen Phone Record Summary for 1113. What is this saying? Motion States Exhibit S1 to motion to reclaim exhibits. Okay. LCSO citation for Bryan on 8/21, which that was one of the days he got pulled over when he was in Moscow. That body cam ended up getting released, a couple months ago. Washington Certified Driver's License Report for Bryan. K-bar knife sheath sample. 1122 King Road diagram. 3D stacked floors. Ground floor, level 2, level 3, King Road area. So that was short. Okay. So next we got, this one's a longer one, but this is, yeah, I'm not going to reread this. This goes over that stuff that we were just reading, but it's like, this one is the extension time. So the extension time for the their expert witness, remember, for the it'd be the mitigation phase. If he gets found guilty, where they're going over, the autism and OCD, but they want to get so it's going to be a lot of repeating on that document we just read. It's probably going to be almost exactly the same. It's for an extension of time to complete rebuttal penalty phase. Complete rebuttal penalty phase expert disclosures. Yeah, it's just going to be like the same thing. State's right to have its own expert witness and to go over like the same stuff to make sure probably they come to the same conclusion about what Bryan's claiming that he has. Remember, this will be under the sentencing phase. So it's the state's motion for exam of defendant. And okay. And these are the experts, Rachel, Lawson, Eileen. These would be defendants made his penalty phase expert disclosure, which included reports from 5 mental health professionals, 2 of whom had been disclosed as guilt phase experts. Okay, so 2 were guilt phase experts. These are his experts that he's getting for mitigation, and then 2 are guilt phase 2. But yeah, so it's going to go over a lot of that same arguments, why they should, but this one is going to focus on why the state should have an extension of time. So I'm not going to go over that again. And I think that's just going to be a lot of repetitive stuff. Okay, so this is filed under seal, declaration of Jason D. Gage. Now, a lot of this is going to be like his history, but let's read the first couple pages of, it'll be more relevant to what. So, okay. Jason D. Gage, PhD, declares and represents the following in support of state's motion for exam of defendant and for motion for an extension of time to complete rebuttal penalty phase expert disclosures. Oh, this is for the rebuttal. This would be their expert. But he's basically given his credentials. I received a PhD in clinical psychology from Utah in 2002. Throughout graduate school, my primary focus was neurodevelopmental conditions such as ADHD and autism. Then joined the Army, completed my internship at Tripler Army Medical, where my primary focus was neuropsychology. Following my internship, I served as the Chief of Mental Health Services. I continued a military service at Mountain Home Air Force Base for 2 years. Basically, given his resume, he worked on a brain injury team. His interest specialties include traumatic brain injuries, medical psychology, PTSD, ADHD, autism. Completing 3 neuropsychological evaluations for adult ADHD and adult autism per week. Okay, so he says, in my professional opinion, including broader testing of personality and psychopathology is important for several reasons. First, because remember, they want to do this personality tests, certain tests, and Bryan's defense is saying, no, they're trying to argue of the relevance of these tests being admissible, or not admissible. I guess it would still be admissible, but for them to be able to bring this expert and have him do these tests on Bryan, he's saying, no, it's not. He's arguing why he doesn't think that it should be done, so now they're arguing why the doctor's going to argue why he thinks it should be. It says, first, these tests contain the most sensitive symptom validity measures that help to determine if the examinee is reporting information in a consistent and reliable manner without significant over-reporting, exaggeration, or under-reporting, defensiveness. In her evaluation of defendant, it does not appear that Dr. Rachel Orr administered any tests that formally evaluate symptom validity to this level. These validity measures help ensure that the results of other self-report measures that do not contain validity scales are valid. Second, not only is it important to rule in diagnoses such as those that have already been diagnosed, but also to rule out of diagnosis that could account for the same symptom presentation. The diagnostic criterion for many disorders includes that the symptoms are not attributed to or not better accounted for by another condition. Therefore, ruling out those conditions is important. Third, with autism specifically, there are certain personality characteristics that are common and supportive of that diagnosis. Obtaining information about those characteristics helps ensure a proper diagnosis. The battery of testing that I propose would be significantly less than the testing battery already completed by Dr. Orr. The battery would serve to supplement the battery that Dr. Orr completed and provide some additional valuable information. In my professional judgment, I would not administer the hair PCLR that is discussed in the report of defense expert John F. Edens, PhD. In my professional opinion, it is inappropriate for several reasons to have any third parties in the room during my examination of defendant. Remember, he said he wanted his people in the room. Even defendant's attorney. First, the normative population that the defendant is compared to consists of individuals who completed testing one-on-one with an examiner without a third party in the room with them. Second, additional people can serve as distraction and affect the validity of the results. Some tests can only be given once since the defendant will start to learn the answers. If distractions occur and that test has to be prematurely terminated, that data will no longer be validated or be valid. Third, test security is of paramount importance as these testing measures influence decisions about public safety in many settings. Section 911 of the American Psychological Association Ethics Code states psychologists make reasonable efforts to maintain the integrity and security of test materials and other assessment techniques consistent with law and contractual obligations in a manner that permits adherence to this ethics code. Having third-party individuals present who do not need to know all of the questions and answers jeopardizes test security for psychologists in the future. This is one reason why raw data is only ethically transferred between psychologists. I have conducted at least 3 mental examinations of defendants in criminal cases, including 1 murder case. I have also conducted many examinations of plaintiffs and defendants in civil cases. In these examinations, attorneys have never been present. On April 25, Dr. Orr contacted me to provide the results from her neuropsychological testing of defendant. I received those materials April 19th, 2025. Provide the results from her. Okay, so she received her results from the testing that they had done, the defense had done. Okay. When I spoke with Dr. Orr, I inquired if any of defendant's attorneys had been present in the room during her exam of defendant. She told me that they were not. I declare under penalty of perjury pursuant to the law that of Idaho that the foregoing is true and correct. So they didn't have them present under for their testing, and so yeah. And then the rest is just his like his resume of everything he's done. So I'm not going to read all that, but to show how qualified he is indeed. Okay, let me see. Let me bring up the next 3 and see what I got. 'Cause I'm tempted to go eat dinner so I could eat with my mom and grandma, but I don't know. So it's this, and this. 3 more. Oh, that's. I don't know. What should I do? Should I change it into a 3-part and go eat dinner with my mom or try to finish it? We're looking at 3 hours. I might end it. So we have 3 more to go, and then I could go over some of hold on. So I have those 3, but then I also have I have more that's requested to be sealed, but then some of the ones I have under boring. Yeah, I won't read those. So I guess I only do have 3 more. I don't. Shoot, I should finish them. No, I'm gonna go eat with them. Okay. I'll try to do another live. We could do these 3 and maybe go over some of the stuff I wanted to point out from some of the interviews. I never got to go over a body cam or anything. Hey Jeff, hey, how are you doing? I haven't seen you around in a while. How are you? Thanks for coming, Brian. Mama Mia, thank you for being here. Christina. Yeah, I mean, Lacey, George, thank you. Gina, thanks guys for hanging out. Cicely. Who else? I'll say you made. I didn't even know you were here. Hello, how are you? Mamma Mia, thank you though. Thank you for. Hey, Spinster. Who else we got? My name is Nikki. We got Jen Jen. Maybe I'll try to do another live tomorrow in the afternoon, maybe. What do you think? Because we got piano in the house. I'm just going back up through the list to say hi to some people. I think I actually did say hi through the lives to everybody. I think I got everybody. I hate saying that though, because if there's like somebody I didn't get, then it makes it like wait, you thought you should, but you didn't say hi to me, and it leaves them out if I say it like that. That's why I shouldn't say that, because I'm sure I did miss somebody. But I mean, it's actually chatting, because obviously there's people that watch that don't chat, and that's totally fine. I'm more that type that likes to just sit back and listen. Nikki, okay, guys. Well, thank you. That's all right, right? I mean, maybe when I do the third one, I could finish these 3 documents, and then I could actually have a discussion of everything too. Let's do it that way. So we'll try to look for tomorrow. I'll finish these, and then I'll maybe even do open panel if anybody wants to come up. I've tried that the last like 3 times I've tried, nobody came up. I could try it again. I could play maybe that Olivia interview, although by tomorrow it'll be 3 days old. Most people probably already seen it, but we could watch it. I could try to, if I can get ready, some highlights of some of the stuff I want to talk about, but maybe not. Maybe I'll just pick one of the more interesting body cams and go over it, because the pre-records I upload, I never got to actually do a live going over the body cams, all the other body cams that came up. But thanks, Brian. Thanks for coming. Thank you, Gina. Thanks, guys. You guys are awesome. I'll see you guys in a little bit. Don't forget, if you guys are any of you guys here are into the Wade case, I've been releasing all those kiosk pictures that I ordered in Patreon, so check that out. I do have a Patreon, and like I said, there's my Patreon, my new Patreon. It's not under zavgirl, it's under Peeping Ears. The link should come up. Why isn't the link coming up? It's not working. Oh, there it is. It'll be a place where, stuff that I'm sure, like after the Wade stuff, I'll have other stuff I'll release there, depending on like if I get files and stuff that isn't like YouTube appropriate, I will release on my Patreon. Thanks, Jeff. Thank you. How is your channel doing? I have thought about you. Like a couple weeks ago, there was something that led me to your channel. I'm like, oh my God, Jeff, I remember when you came up on panel that one day. And I like wonder how he's doing. Anyway, all right, guys, have a good one. Cat mouse. I know I better go for dinner, because the whole point is to eat dinner with them. And if I wait too long, it'll be too late anyway. All right, bye, guys.